Bonjour, mesdames et messieurs. Je m'appelle Hamid Georgiani et en ma qualité de président de ce groupe de réflexion sur le Moyen-Orient, c'est un grand plaisir de vous accueillir et vous souhaiter la bienvenue à la deuxième événement de notre programme pour cette année. As we begin, I would like to acknowledge that I'm speaking to you from the unceded territory of the Algonquin people, the traditional territory of the Wendat and Haudenosaunee Confederacy. May we honor the indigenous stewards of this land and grow in right relationship with all indigenous people. Aujourd'hui, je suis très heureuse d'accueillir notre conférencier distingué, professeur Dr. Ardi Imseis, who is Assistant Professor of Law, the Faculty of Law, Queen's University, and a member of the group of eminent international and regional experts, the UN Human Rights Council Commission of Inquiry into the civil war in Yemen. And he has been in that position since 2019 to 2021. An important thing about Dr. Imseis is that he has been in the Middle East, in Palestine, under the auspices of UN for almost 12 years. So he has a great deal of field experience. He has been there and he knows the region very well. And under UN, he is very familiar with different programs and different initiatives of the UN in that region. You all have received a detailed biography of Ardi, and I won't go through details in the interest of times. And I would like now to pass on the microphone to our eminent speaking, our keynote speaker. Ardi, it's yours.
Thank you so very much, Hamid. I would like to, before I begin, just extend my thanks to the Canadian International Council for inviting me to address you today. Throughout its history, Canada has played a significant role in the creation and upholding of the rules-based international order, which is instrumental to the preservation of global peace and security. When these rules are challenged, Canada must stand up and work with its allies to prevent their deterioration. These are not my words, ladies and gentlemen. These are the words of a 15 January press release from Global Affairs Canada, ahead of Minister Joly's recent visit to Europe, where, according to the same press release, she affirmed, quote, Canada's steadfast support for Ukraine's sovereignty and territorial integrity, end quote, and its opposition to, quote, Russia's aggression and ongoing destabilization activities in and around Ukraine. Of course, the minister wasn't speaking on her own initiative. To mark what Ukraine calls its national, quote, day of resistance to the occupation of the Autonomous Republic of Crimea and the city of Sevastopol on 26 February last year, Joly's predecessor, Mr. Garneau, then reiterated Canada's, quote, unequivocal condemnation of Russia's illegal invasion and annexation of Crimea, and affirmed that Canada stands with the people of Ukraine who continue to fight tirelessly for their fundamental rights and freedoms, end quote. To underscore the point, Garneau stated, quote, that for 7 consecutive years, Russia has repeatedly ignored calls from the international community to reverse its decision to illegally annex and occupy Crimea, which grossly violated Ukraine's sovereignty and territorial integrity. Russia must comply with its international obligations and cease its illegal occupation of Crimea. To that end, Canada has joined a number of countries to impose sanctions on Russia to hold it accountable for its actions. Because Canada has invoked its fidelity to the rules-based international order in justification of its resolve to apply sanctions on Russia, I suppose the best place to begin with is with reference to the 2 core principles of international law that underpin Ottawa's position on Russia's occupation of Crimea. First is the principle prohibiting the acquisition of territory through the threat or use of force. This is a corollary of Article 2, subsection 4 of the UN Charter, which imposes a general prohibition on the use of force in international law. Second is the right of peoples to self-determination. The normative force of these 2 core principles is expressed in the general rule that governs the law of belligerent occupation. That occupation of enemy territory is meant to be temporary and that the occupying power may not, by virtue of its occupation, rightfully claim sovereignty over such territory. Now, the international lawyers amongst you will recognize these two principles as jus cogens or peremptory norms of international law, derogation from which is not permitted. The reason for the absolute character of these principles is self-evident. Any other approach would propel us collectively back to the 19th century and beyond, a time when, to quote von Clausewitz, war was a continuation of policy by other means and territorial conquest perfectly legal. So you might ask, why would any of this matter for Canada in the Middle East? Well, the short answer is that by all objective accounts, Ottawa seems to be playing fast and loose with its purported commitment to these bedrock principles of international law. Nowhere is this made more apparent than when we juxtapose Ottawa's sound position on Russia's occupation of Crimea with its severely duplicitous one on Israel's occupation of Palestine. Since 1967, Israel has been in belligerent occupation of the West Bank, including East Jerusalem and the Gaza Strip. At the United Nations, where I served in East Jerusalem and Gaza City for 12 years, these areas are collectively known as the Occupied Palestinian Territory, and since November 2012, the State of Palestine. During Israel's unusually prolonged 54-year occupation, it has pursued a policy of systematically and forcibly altering the status of occupied Palestine with the open and public aim of annexing, de jure or de facto, most or all of it. This has been done in violation of the very same bedrock principles purportedly underpinning Canada's position on occupied Crimea, namely the inadmissibility of territorial conquest through force and the right of peoples to self-determination. At the heart of Israel's violations of these principles is its policy of transferring its own civilian population into the occupied Palestinian territory in violation of the Fourth Geneva Convention, the Rome Statute of the International Criminal Court, and customary international law. According to a 2013 UN fact-finding mission, each Israeli government since 1967 has, quote, openly led and directly participated in the planning, construction, development, consolidation, and or encouragement of settlements in the OPT, the Occupied Palestinian Territory, through various political, military, and economic means. Today, according to the UN Secretary General, between 19 and 23% of the population of the West Bank, including East Jerusalem, some estimated 700,000 persons, are Israeli settlers, and their numbers continue to grow. The illegality of the settlements has been affirmed by each of the relevant principal organs of the United Nations countless times over the years, including the Security Council, the General Assembly, the Economic and Social Council, the Secretariat, headed up by the Secretary General, and of course, the principal judicial organ, the International Court of Justice. In this regard, most relevant for assessing Canada's position is Security Council Resolution 2334 of 2016, which affirms that the settlements have, quote, no legal validity, end quote, and constitute, quote, a flagrant violation under international law. That resolution further calls upon all states, bearing in mind the illegality of the settlements, quote, to distinguish in their relevant dealings between the territory of the State of Israel and the territories occupied since 1967. I underscore that obligation on Canada to distinguish its relevant dealings between the territory of the State of Israel and the territories occupied since 1967. So in view of Canada's purported commitment to the rules-based international order, one would expect Ottawa to scrupulously follow the terms of Council Resolution 2334. Unfortunately, this has not been the case. While Global Affairs Canada indicates that Canada's official position remains that Israel is indeed an occupying power in the OPT, the Occupied Palestinian Territory, and that Israeli settlements are indeed a violation of the Fourth Geneva Convention, the government has pursued a policy that by all accounts aids and assists in the maintenance of this violation. Canada's culpability rests in its policy of allowing for the duty-free import of Israeli settlement products under the terms of a bilateral treaty known as the Canada-Israel Free Trade Agreement, or CIFTA. Under CIFTA, Israel territory is defined not by Israel's national borders, as Canada's is defined under the agreement by its own national borders, but rather as, quote, the territory where Israel's customs laws are applied. Citing the 1995 Paris Protocol, a temporary agreement between Israel and the Palestine Liberation Organization, which purported to create a single customs union between the OPT under Palestinian self-governing control and Israel, the Attorney General of Canada now takes the position that it is reasonable to label Israeli settlement products as, quote, products of Israel when they are imported into Canada, duty-free. For its part, the state of Palestine has made it clear that, quote, at no point has it acquiesced in the view that any portion of the occupied Palestinian territory forms part of the state of Israel for any purpose, including matters of customs and trade, end quote. At any rate, under various articles of the Fourth Geneva Convention, see Articles 7, 8, and 47, no special agreement between an occupying power and an occupied population, such as the Paris Protocol, can be allowed to derogate from the rights of the convention confers on the protected population, in this case, the Palestinian civilian population. As some of you may know, a challenge to this labeling issue, this settlement labeling issue, is being brought by one concerned Canadian, Professor David Kattenberg, and the matter is now working its way through the federal court. For Canada, however, the most important points are this. 1, on its face, the terms of CIFTA are illegal under international law for being in violation of the two peremptory norms earlier noted, namely the prohibition on territorial conquest and the obligation to respect the right of peoples to self-determination. For the lawyers among you, see Article 53 of the Vienna Convention on the Law of Treaties for support for that. 2, the terms of CIFTA do not comport with Canada's obligations under Security Council Resolution 2334 to distinguish, in its own terms, in its relevant dealings with the territory of the State of Israel and the territories occupied since 1967. And I should like to add in parentheses that the labeling of settlement products is not really the issue, shouldn't be at least, as a matter of international law, but rather the wholesale banning of such products into the Canadian markets should really be what the Canadian government goes for if it wishes to remain in conformity with its obligations under international law. 3, Canada is also clearly in breach of its obligation to respect and to ensure respect of the Fourth Geneva Convention, see Common Article 1 of that convention. And 4, the same is arguably true of Canada's obligations under the Rome Statute of the International Criminal Court, which make it clear that settlements are war crimes, see Article 8. Finally, under the law of state responsibility, instead of aiding and assisting Israel in its violations of international law in occupied Palestine, Canada is obligated actually to cease this conduct forthwith. So much for Canada's principled rules-based position on illegal military occupation. Another aspect of Canada's policy on Israel-Palestine that runs counter to its ostensible commitment to the rules-based international legal order is its position on Palestine's accession to the Rome Statute of the International Criminal Court. As is well known, Canada often boasts of the pivotal role it played in the creation of the ICC. It was the first state party to domesticate the Rome Statute, and it has continued to support the court in its operations and to encourage universal ratification of its statute by all states. At a meeting of the Assembly of States Parties, for instance, in 2015, Canada affirmed, quote, that the ICC is an independent judicial body and as such must be free from political interference, end quote. It further committed to, quote, work together in a spirit of cooperation in pursuit of our common goal of ending impunity and delivering justice for the victims of the most serious crimes of concern to the international community as a whole, end quote. On 20 December 2019, the Office of the Prosecutor, OTP for short, of the ICC concluded its 4-year preliminary examination into the situation in Palestine. The prosecutor determined that there is a reasonable basis to initiate an investigation into the situation in Palestine, and that she was satisfied that 1, war crimes have been or are being committed in the West Bank, including East Jerusalem and the Gaza Strip, including in the form of Israeli settlements, which we've discussed. 2, potential cases arising from the situation would be admissible before the court. And 3, that there are no substantial reasons to believe that an investigation would not serve the interests of justice. Instead of initiating an investigation, as she was entitled to do, the prosecutor decided to seek a ruling of the pretrial chamber, quote, on the scope of the court's territorial jurisdiction in the situation in Palestine. Very important. This is the question before the court. On the scope of the court's territorial jurisdiction in the situation in Palestine. Specifically, she sought confirmation that the territory over which the court may exercise its jurisdiction under the Rome Statute comprises the occupied Palestinian territory, namely the West Bank, including East Jerusalem and the Gaza Strip. To assist in this task, the pretrial chamber invited states to submit observations on the question before the court. Of the 123 states parties to the Rome Statute that could have made submissions, only 7 did so. And while Canada did not join them, it did nevertheless submit a bilateral communication directly to the court. So not part of the judicial process and not for public consumption effectively. Based on what we know, it is apparent that the intervention of the 7 intervener states, what we know from the public record, the intervention of these 7 intervener states, including Canada, was the result of a political lobbying effort on the part of Israel, who is not party to the statute. A critical examination of these observations reveals that they shared a common denominator of sorts, namely that none of them attempted to answer the question posed by the Office of the Prosecutor on the scope of the court's territorial jurisdiction. That is, where the court may exercise jurisdiction within the state of Palestine. Rather, they instead advanced a number of arguments aimed at impugning the very notion that the court has any jurisdiction at all on the basis that Palestine is not a state and therefore does not have the capacity to accede to the statute. Thus, Canada's communication to the court purportedly affirmed that, quote, it does not recognize a Palestinian state and therefore does not recognize the accession of such a state to international treaties, including the Rome Statute, end quote. Notwithstanding these attempts to derail the course of justice, the pretrial chamber eventually did rule that it does indeed have jurisdiction over the situation in Palestine, and that the scope of the court's territorial jurisdiction is indeed the territory of the state of Palestine, being the occupied Palestinian territory. On March 3, 2001, the Office of the Prosecutor finally launched its investigation, which continues and is ongoing. Now, none of this is to say that Canada is bound, as a matter of international law, to recognize Palestine as a state. And while I happen to personally hold the view that Palestine is a state under international law, and I'm happy to talk to you in question and answer on that, and that recognition by Ottawa would be the right political thing to do at this time, that's my view, I well appreciate that policymakers in Ottawa still have questions about that. Nevertheless, when it comes to the fight against impunity for perpetrators of the most serious crimes of concern to the international community, which is the very object and purpose of the Rome Statute that Canada claims to have profoundly supported over the years, one is left wondering why, when Palestine has attempted to legitimately avail itself of this nonviolent legal means of redress, Canada could not have simply abided by that age-old maxim of doing no harm by joining the majority of states parties and simply remaining silent on the matter of Palestine's accession. To put things in perspective, it is helpful to set out what would have happened had the court accepted Canada's position on the matter. In short, the same accountability which Ottawa seeks for Russia's transgressions in Crimea would have remained elusive for countless unnamed victims in Palestine, and it should be said, Israel. The prosecutor's request to the pretrial chamber identified at least 4 areas where war crimes have been or are being committed illegally in illegally occupied Palestine, namely the killing by Israel of over 2,200 Palestinians, including 1,400 civilians and 300 women and 550 children, in addition to 11,000 injured and over 500,000 displaced Palestinians during the 2014 Gaza hostilities. The killing by Palestinian armed groups during the same hostilities of 6 Israeli civilians with 1,600 injured, the transfer of over 700,000 Israeli settlers into the occupied West Bank, including East Jerusalem, as we've discussed, and the lethal shooting by Israeli armed forces of over 200 Palestinian civilian protesters, including over 40 children, and the wounding of thousands of others at the Gaza border, beginning in March 2018. These crimes were considered by the prosecutor as, and this is an important point, illustrative only, in her words, and without prejudice to the expansion of her investigation to account for other criminal acts. And based on the UN record alone, these plausibly include crimes against humanity committed by Israel in the OPT, in particular, any of the following acts when committed as part of a widespread and systematic attack directed against a civilian population with knowledge of the attack: deportation or forcible transfer of a population, imprisonment or other severe deprivation of physical liberty in violation of fundamental rules of international law, torture, persecution against an identifiable group or collectivity on political, racial, national, ethnic, cultural, or religious ground, and finally, the crime of apartheid. All of the above has produced a climate of endemic impunity in occupied Palestine in respect of the situation there, as affirmed by successive UN-mandated independent international fact-finding missions over the past decade. Thus, in 2009, the Goldstone report decried, quote, that the prolonged situation of impunity has created a justice crisis in occupied Palestine, end quote. Likewise, a 2013 Human Rights Council independent report into the implications of Israeli settlements called upon Israel, quote, to ensure accountability for all violations, including for acts of settler violence and to end the policy of impunity, end quote. Similarly, a 2015 Human Rights Council report noted, quote, that impunity prevails across the board for violations allegedly committed by Israeli forces, end quote. And finally, in 2019, another Human Rights Council independent report, this time into the protests at the Gaza border, noted, quote, Israel has consistently failed to meaningfully investigate and prosecute commanders and soldiers for crimes and violations committed against Palestinians, end quote, and that, quote, paltry accountability measures cast doubt over the state's willingness to scrutinize the actions of its military and civilian leaders, end quote. In view of this culture of impunity documented by the United Nations, and I've only given you a bit of it, frankly, which makes clear that Israel is unwilling or unable to genuinely carry out investigation and prosecution of these actions in its actions in illegally occupied Palestine, it is more than clear that the only recourse available for justice and accountability for the victims of years of violations of human rights in occupied Palestine remains the International Criminal Court. And yet Canada chose to stand in the way. In conclusion, it should be self-evident that international law is only as strong as the willingness of states to ensure its universal application. Unfortunately, when one scratches away at the surface of Ottawa's high-sounding postulations of principle, one is hard-pressed to take seriously Canada's purported fidelity to the rules-based international legal order. The very same principles it purports to be driving its progressive foreign policy agenda in places like occupied Crimea are being blatantly violated by it when it comes to Israel-Palestine. The result, of course, is to cast a long shadow of hypocrisy on Ottawa's image in the world, a shadow which by all accounts has and will continue to result in costs for Canada on the international stage. Nowhere is this evidenced more than with Ottawa's failure to twice gain a seat on the UN Security Council in as many tries in recent years. But I'm here to tell you that it needn't be so, friends. And one of the keys for this is to ensure that Canada makes right its commitment to the universal application of international law, and to not cynically invoke international law when it suits its narrow domestic or geopolitical interests to do so. And with that, I'd like to thank you and hold it open for questions.
Thank you very much, Ardi. It was a very detailed legal analysis of the situation, an area which I have no expertise, so I can't express any opinion. Suffice it to say that the purpose of this session is basically to encourage an intellectual debate about the situation and with a lens, with the international law as the background. And with that, I would like to invite our participants to submit their questions through our Q&A button, which is provided under the frame that we have. And while friends are providing us with questions, I have one general question, and that is, in the beginning, I mentioned that you have had the experience of being there for 12 years. Now that we have a different government in Israel, how do you see the situation, and what are the prospects for peace or reconciliation now?
Hamid, thanks very much for that question. Yes, I spent between 2002 and 2014 over there, living full-time and working with the United Nations, as I said, in Gaza Strip, East Jerusalem. I would travel very regularly in and out of Israel and was engaged with pretty much every member of society that you can imagine. The short answer is there is no prospect at all, whatever, for peace on the basis of international law to be found with the government that currently is in power in Tel Aviv. I should say to you as well that this is not new. Just as I'd mentioned in my talk, for instance, in respect of the settlements policy of each successive Israeli government, this is a policy that runs throughout. It is a common feature of the left and the right in Israel proper. And if anything, in the time that I spent living there, I'd only seen a shift towards the right, or if we can call it that, among Israeli Jewish society. More and more Israelis are increasingly feeling as though their backs are against the wall and going for more and more Palestinian land. There is a seamless connection for Israeli Jews who live in occupied Palestine between them and Israel proper, as it were. There's no difference for these people politically, in the cultural imagination, in the financial world, in the economic world, and certainly in the social world, between occupied Palestine, where they live in those areas, and Israel proper. And it will take some action, heavy lifting, if you like, on the part of the international community to change the equation. Unfortunately, the Palestinians have no ability whatever to influence the Israelis on this score, just given the power imbalances between them. So accountability matters, and international law matters, and the international community and third states, including Canada, have a definite role to play.
Thank you. Related to this was the point that you raised earlier, and that was pertaining to recognition of the state of Palestine. And you mentioned that our policymakers are still having questions about that. Would you elaborate on that? What sort of questions, and what is really involved?
Sure, absolutely. Look, I only surmise that they have questions. I don't know exactly what those questions are. What I can say, based on what I know, which is a matter of public record, is that Canada does not recognize Palestine. And so we must ask ourselves logically, well, why ever would they not recognize Palestine? There can only be a few reasons. One, politically, Canada is of the view that Palestine can only be recognized until such time as the parties to the conflict negotiate a final resolution of the conflict, which allows for the emergence of an independent, free, sovereign Palestinian state in the occupied Palestinian territory or thereabouts. That's the political position of Canada. One might also surmise that Canada takes this view because Palestine, as a matter of international law, does not qualify as a state, and international law thankfully offers us objective criteria on which this question, the question of whether or not an entity amounts to a state, is indeed a state. And this is to be found in a treaty called the Montevideo Convention on the Rights and Duties of States, dated 1933, which codifies customary international law on the 4 criteria for statehood. These criteria are as follows. 1, a permanent population. 2, defined territory. 3, a government. And 4, the capacity to enter into foreign relations. And I've done work on this and have published recently an article on it at the Leiden Journal of International Law. It's part of the book that I'm working on as well. By all accounts, Palestine, based on state practice and state practice's application of this 4-pronged criteria under the Montevideo Convention, by all accounts, the state of Palestine fulfills these criteria. It has a population that is permanent. Nobody would even guess that. That's not a matter of dispute. It's been there from time immemorial. In fact, much of its population is also refugees, but it has a sufficient population based on state practice. We know this because there are states out there who have very small numbers of population, San Marino, Luxembourg, and so on, very small in number. So if it's good for them, then certainly it's good for Palestine with 4.5 million Palestinians living in the West Bank and another 2 in Gaza. It has a defined territory. Some have argued that, in fact, the territory isn't defined because the borders of Palestine they're only made up of an armistice agreement, and under armistice lines between Jordan and Israel, these are not political borders and so forth. But again, looking at state practice, states, entities have been admitted to the United Nations as states where their borders have been far more porous, if you like, or unknown. Indeed, the best case to look at there is Israel. When Israel was admitted as a state to the United Nations in 1949, it did not have fixed borders with any of its neighbors. It only had a few armistice agreements with the various warring parties that it had just finished hostilities with. And yet that was sufficient enough to allow it membership in the United Nations as a state. So again, a flexible application of that criterion. The same flexibility is applied to effective government. Palestine has a government sufficiently enough to satisfy the Montevideo Convention. It has a president, it has various chambers of government, it has elections, although not now, but it did. It has a functioning public sector, various ministries, and so on. So when measured against other states who've applied for membership in the United Nations as states and who have had less objectively, if you like, qualified government, say the Congo in 1960, it applied for membership in the United Nations. It got it at a time when there were 2 warring parties in Congo actually in a conventional civil war. And the UN, it was so bad that the UN didn't even know who to give Congo a seat in the General Assembly to. Nevertheless, Congo was admitted as a member state of the United Nations. All this to say, this test, the Montevideo Convention test, has been applied very liberally, very flexibly. And finally, the foreign relations capacity criterion. Palestine has been exercising that independently since 1975, 76, as recognized by the United Nations through the Palestine Liberation Organization. And it has a very rich treaty practice, rich bilateral relations. In fact, there are 139 states in the world that recognize the state of Palestine, and there are only 193 members of the United Nations. So Canada finds itself in not recognizing Palestine in the minority in that regard. So all told, Palestine is a juridical state. It certainly isn't free. Its sovereignty is being impeded by an illegal occupying power, and that's the point. And that must end. And that's where Canada and third states come into play.
In regards to the points that you raised in the past, some of our speakers have referred to the fact that lack of a robust government in Palestine is one of the issues why this negotiation cannot take place. And the points they're making is that Palestine is currently divided between different factions, and there is no proper government that could be sitting at the negotiation table on behalf of the entire Palestine and negotiating with their counterparts. What is your opinion about that?
Yeah, thanks for the question. Sure, I've heard that one before. In fact, I recall in the 1980s, it was de rigueur to hear that there was no Palestinian negotiating partner. The PLO was on the outs. Nobody would really talk to it until such time as the PLO recognized at Algiers in 1988 the state of Israel in 78% of Mandate Palestine, renounced terrorism, if you can recall, and then sat down at Madrid. Since the Madrid peace process in the early 1990s and today, I think the public record is very clear that the Palestine Liberation Organization, which is not divided, the Palestine Liberation Organization, which represents the Palestinian people wherever they are globally and conducts their foreign relations and enters into agreements with Israel, not the Palestinian Authority, has bent over backwards, primarily through its historic compromise to recognize Israel in 78% of mandatory Palestine, with the goal, of course, of ending the occupation on the lines of 1967. What you have on the other side, if you like, on the Israeli side, and these are facts about which there's no disagreement not even among members of the Israeli government. You have the trebling, really, of the population of Israeli settlers in occupied Palestine. So in 1993, on the eve of the Oslo process, there were about 190,000 settlers across the West Bank, Gaza Strip, and East Jerusalem. Today, that number is 700,000 or more. And this, of course, violated the temporary agreements entered into at Oslo, which made it clear that the parties would not prejudge final status. But more than that, anyone who opens up a newspaper in the Hebrew language, say the Haaretz, would find today countless statements made by the Palestinian president, by members of the PLO, willing to go back to the negotiating table with the Israelis. The question is whether or not it's the same is true on the other side, and you will not find that. As a matter of public record, Benjamin Netanyahu, the last prime minister, and particularly the current prime minister, Naftali Bennett, his cabinet, these folks are all very clear as a matter of public record that the only people who enjoy a right to self-determination in what they call Eretz Israel, or mandatory Palestine, are the Jewish people, and to the exclusion of all others. And there can be no establishment of a Palestinian state anywhere west of the Jordan River. That's a matter of public record. So for those who point at divisions within the Palestinian camp that is within the occupied Palestinian territory, and they're there, there's no doubt about that. There's divisions between Hamas and Fatah, no doubt about that. As reason to suggest that there can be no negotiations, I think have it backwards. The Israelis have been in foreign military occupation, purportedly a temporary occupation, for 54 years of somebody else's land. They've been violating chapter and verse, the Fourth Geneva Convention, the Rome Statute, and more than that, they've done so publicly, brazenly, and have every intention not to stopping their colonization of this territory. I'd suggest to you that the focus of inquiry on the bona fides of who's interested in negotiating have to be focused on Tel Aviv, not the Palestinian Authority.
We have lots of questions, and the first one is a short one. Can Canada play a significant role to find a solution between Palestinians and Israel?
Absolutely. The short answer is yes. Canada can do, and the best part is Canada doesn't need to reinvent the wheel. The only thing that is required to bring peace among Israelis and Palestinians is to apply public international law, right? International law are the rules which govern relations between states, and it's the rules by which states agree that they will play the game, as it were, on the international arena. And so if Canada wants to play a constructive role, it must not only call out violations of international law when they take place, but it must ensure that it doesn't violate its obligations vis-a-vis the parties to the conflict. As I've set out, they're clearly doing hypocritically with respect to settlements or Palestine's position on ICC. But it can be even more constructive than that. Some states choose to sit on the fence and say, well, the parties to the conflict need to negotiate between themselves a final resolution. And that's all in good. It sounds good. But when you look at what's going on the ground, as I've lived it, and you see the difference in negotiating positions between the parties. One is a nuclear Western state, the other a fledgling state that has very little capacity to protect itself and its people. I mean, the president of Palestine cannot travel out of Ramallah without the authority of the local Israeli military commander. So when looked at those power imbalances, it is, to my mind, folly to suggest that the parties should negotiate a resolution bilaterally between themselves, if indeed an international law-based peace is to be had one day. This is where third states like Canada need to build up a little bit more muscle and tell their friends in Tel Aviv, sorry, mates, Israel is a safe and secure state. You have your country. It's called Israel. The issue here is you don't have sovereignty in occupied Palestine. You cannot, as a matter of international law, have any sovereign claim to that territory because you're an occupying power. And therefore, we will take measures to ensure that we will abide by our international legal obligations not to allow, for instance, illegal settlement products to have access to Canadian markets duty-free. Or we will cooperate with the International Criminal Court to ensure that perpetrators of war crimes, crimes against humanity, and other such don't go free, if you like, and enjoy impunity, and so on. So there's much that Canada can do. I mean, it's even legislated in our domestic law, right? The Fourth Geneva Convention is domesticated in Canada. Canada has an obligation to ensure its enforcement. So when those who are responsible for building settlements and doing so publicly and making clear that they have no intention of stopping, come to Canada, the Canadian government has a choice, right? And that's where Canada can step in.
There is an anonymous question about the announcements last week regarding the practices in Israel, which antagonized a lot of people in Israel because the term was strong for them. And the question is, do you think that this perspective will be taken into more consideration within the UN system and so on?
Before I answer the question, Hamid, I note now that it's rather dark in the window in front of where I'm sitting. So I'm going to turn on the light and I'll be right back. Bear with me.
Sure.
I should like to apologize to your viewers for that darkness. Now I'm in the light. There you are.
Yes, that's right. So now perhaps...
So can you please ask that question once again?
Last week there was an announcement by Amnesty International regarding the whole issue of apartheid and all that. And now the question is, do you think this perspective will be taken up more in the UN system or be used at the ICC? And I was mentioning that it created a lot of negative response from Israel and wasn't a pleasant thing to the ears of many of our colleagues and friends who are associated with Israel.
Of course, it's a good question. It's pressing and timely, of course. I suppose the first place to look at is the very first place to look is to the merits of the claim. Amnesty is not alone. Amnesty International, Human Rights Watch over the summer, so the two leading human rights organizations on planet Earth, plus Israel's own leading human rights organizations, B'Tselem and Yesh Din, have all within the last 2 years determined that Israel is engaged in apartheid to certain extents. So the Human Rights Watch report focuses on apartheid claims in the occupied Palestinian territory. B'Tselem argues on both sides of the Green Line. The regime that has been put in place by Israel since 1948 is one of, and I'm using their words, not mine, Jewish supremacy. Yesh Din argues that acts of apartheid are taking place in the OPT, again, in the occupied Palestinian territory. And Amnesty International argues that apartheid, again, is going on both sides of the Green Line and going back to 1948. There are many claims that are made that are very detailed in these reports, which I've read. I've not completed the Amnesty International report, but have read its executive summary. I've read all the others. And it all comports with what I've seen living and working on behalf of the United Nations on the ground. Take, for instance, to begin with, the idea that Palestine refugees or Palestinian refugees are prohibited from returning to their homes and their properties in what is today Israel. Sounds pretty difficult to discuss the right of refugees to return, but let us recall a few facts, again, about which there is no disagreement between Israelis, the government of Israel, and the state of Palestine or anybody engaged. Fact number one, on the eve of the war in 1948, the Jewish community in Palestine represented only 1/3 of the population of the country, and they only owned less than 6% of the whole of the country. By the war's end, say an 18-month war, 80% of the population of what became the Jewish state was ethnically cleansed. 80% of the Palestinians living in it, they were ethnically cleansed and their property was taken. By the end of the war, Israel comes into control of 78% of the whole of Mandate Palestine. And then they create a number of bodies, the Israel Lands Administration, the absentee property body, to basically take Palestine refugee property and hold it in perpetuity in the name of the Jewish people by transferring it to the Israel Lands Authority and so on. This is Palestine refugee property or state property, right? For which nobody's ever been compensated. But more than that, the people who were ethnically cleansed have been unable to return by virtue of one fact. They're not Jewish, right? Palestinian refugees cannot return under Israeli legislation, and the legislation is the law of return on the one hand, which affirms the right and establishes the right of any Jew anywhere in the world to return to Israel. And the moment they do, they can get citizenship immediately, even though they've never had any connection at all to the place, right? That's why you have French Jews coming, never been to Israel, they come, they immigrate, ready to go, they can get citizenship. And then the nationality law of return of 1950, and the nationality law of 1952, which says that that only nationals of Israel can enjoy full rights. And if you weren't in Israel on the day Israel's independence was proclaimed, then you're not entitled to nationality in the country. Many folks don't really appreciate that there is no such thing in Israeli law as Israeli nationality. It doesn't exist. There's Jewish nationality in Israel. There's no such thing as an Israeli national, and only Jews have full national rights in Israel. So I only raise this as one example, and there are many, many, many other examples, and I would commend your readers to actually read the reports that allege Israel is committing apartheid, read the detail of those reports and respond to them if they can. But I only give you this one example to demonstrate that there's a systemic racialization, if you like, of rights, access, obligations, duties that are based on immutable characteristics, people's religion, people's national origin. And it's rather widespread. So what I believe in terms of answering your question, in terms of what the UN, what value this report will have at the UN, whether or not it'll grow legs at the UN and be picked up, I do think that it's inevitable that it will. It depends on what UN you're talking about. The UN is made up of 6 principal organs, and they all have their own political dynamics. So the apartheid claims will not go anywhere at the Security Council by virtue of the dynamic that exists at the Security Council. Israel is well protected by its relationship with the United States. Certainly on the apartheid question would be equally well protected by its relationship with the United Kingdom and possibly France. Maybe not so the others as much, and it would depend. In the General Assembly, a different political dynamic dominated by the Third World, very sensitive to the events in apartheid South Africa and the anti-apartheid movement and struggle. So a completely different thing. At the Human Rights Council in particular, you'll have it picked up. There is a commission of inquiry that has been established by the Human Rights Council on Israel-Palestine. It has a mandate that is very broad, it goes forward in time, but back in time as well to, quote, root causes of the conflict. And that commission of inquiry will be dealing with the same facts, details, allegations that are put forward to us through the Amnesty International report. And the challenge there for those who disagree with the apartheid qualification is to answer the following question. Is Israel engaged in the act of apartheid as defined under international law? Not whether or not it's similar to South Africa or any of that, no. Is it engaged in apartheid? And if the detractors of Amnesty International can't answer that question, then I suspect that this discourse will only increase and make matters worse, I think, for Israel, but ultimately good for the international rule of law. Racial discrimination is to be abhorred, period, and most especially in Palestine.
Maybe related to the discussion that we have right now is, why would the West Bank or Gaza be considered occupied today when neither Egypt nor Jordan claims those territories, and they were not considered occupied before 1967? And why would those territories be considered Palestinian today and not before the 1967?
Sure, good questions. Very good questions, actually. I suppose the place to start when one wants to talk about whether or not a territory is occupied is Article 2 of the Fourth Geneva Convention. The Fourth Geneva Convention is the main treaty that governs situations of belligerent occupation. and it makes it clear that that the convention applies to the territory of all high contracting parties after they engage in an international armed conflict, and that the one party's armed forces subjugate the other party's armed forces and establish effective control. The effective control test goes back to the International Military Tribunal's judgments at Nuremberg, see the hostages case, and also the 1907 Hague regulations. I think it's Article 43, if my recollection serves, maybe 42. But the test for the beginning of an occupation under international law is when the territory of one party is entered upon by a state of another party, and they establish effective control and replace effectively the ousted sovereign, right? The government that is there no longer is resisting or able to mount an effective resistance, then that effective control brings along with it the law of belligerent occupation. This implies an enemy, if you like, characterization. States who invite other states into their territory are not occupants. Say, for instance, in Yemen, the Yemeni government has invited Saudi Arabia and UAE into its territory to help it. That territory that is controlled by Saudi Arabia and UAE, to the extent that they do have effective control, is not occupied by virtue of the fact that they've been invited there by the legitimate sovereign, right? So Jordan came into control of the West Bank in 1948-49, and Egypt control of the Gaza Strip on the authority of a decision taken by the Arab League to help Palestine on the secession of a new state from Palestine, Israel, through force, right? So a perfectly legitimate thing for the Arab states to have entered mandate Palestine to aid and assist the local Palestinian Authority, being the Arab Higher Committee and the All-Palestine Government. So that might answer the question as to why Jordan was not an occupying power in the West Bank or Egypt an occupying power in Gaza between 1948 and 1967. The reason why Israel becomes an occupying power is rather clear, because during the course of the international armed conflict between Jordan, Egypt, and Israel and others in 1967, Israel came into control of these territories. It was not sovereign in these territories prior. And the international community, through the General Assembly and the Secretary and the Security Council, made it clear that Israel was there as belligerent occupant. I should add this as well, according to the Israeli record, right in August, so less than a few weeks after they took the West Bank, an order was issued by the military authorities, the Israeli military authorities, to apply the terms of the Fourth Geneva Convention to the West Bank, Gaza Strip, and East Jerusalem, recognizing that they were indeed an occupying power. And in the next 3 months, by October, they had rescinded this order. And this was because Israeli military commanders and their legal advisors realized that if they agreed to abide by the terms of the Fourth Geneva Convention, which again is the principal treaty that governs belligerent occupation, they would be prohibited from settling that territory.